Hello and welcome back to Eductainment. In today's video, we're exploring an important part of the Factory Act, 1948, the definition of a worker under Section 2L. Whether you're a factory owner, manager, worker, or just interested in labor law, this video is for you. Understanding who qualifies as a worker helps ensure fair treatment and legal protection for everyone involved in the manufacturing process. Ready to dive in? Let's get started. So, what exactly does Section 2L say about workers? It's simple. A worker is anyone doing work connected to the manufacturing process, whether directly hired by the factory or through an agency or contractor. It doesn't matter if they're full-time, part-time, temporary, or even unpaid. If their job supports the manufacturing process, they're considered a worker under this law. For example, imagine you're hired through a contractor to help build a new assembly line in a factory. You might not be on the factory's payroll, but you're still a worker under the Factory Act, and you're entitled to the same legal protections as full-time factory employees. This ensures that no one is left out just because of how they're hired. Whether you're directly employed by the factory or hired indirectly through an agency, you're still covered. Let's break this down. Direct employment is straightforward. You're on the factory's payroll. But indirect employment means you're hired through a contractor or agency, or maybe even a third party. You might be paid by them instead of the factory itself, but you're still a worker. Here's an example. A factory hires a contractor to install new equipment. The workers doing the installation are paid by the contractor, not the factory. But guess what? They're still protected under the Factory Act. Why? Because their work is essential to the manufacturing process. The law doesn't only protect workers directly involved in production, it also covers those who maintain equipment or facilities. Let's think about the cleaning staff, maintenance workers, or machine repair technicians. They might not assemble products, but their work keeps the factory running smoothly. Under Section 2L, these individuals are also considered workers and enjoy the same rights and protections. What's fascinating is that even unpaid workers are covered under this law. So, if you're an intern or volunteering in a factory setting, you're still protected. You don't have to be on the payroll to qualify as a worker. Imagine an intern helping with machine setup in a factory, even without a paycheck. That intern is still a worker under the Factory Act. This prevents employers from exploiting unpaid labor and ensures that everyone in the factory is treated fairly. A unique aspect of Section 2L is that a worker can be employed with or without the principal employer's knowledge. So even if the factory owner isn't aware of the worker's hiring, say a contractor brings in extra hands for a project, those workers are still protected by the law. This ensures that no one is denied their rights, no matter the circumstances of their employment. This broad definition of a worker is essential. It prevents employers from exploiting loopholes in hiring practices. Temporary workers, contractors, maintenance staff, and even unpaid interns all fall under the protective umbrella of the Factory Act. It guarantees that everyone working in a factory setting is entitled to the same legal rights, safe working conditions, fair wages, if applicable, reasonable working hours, and compensation in case of injury. To understand the practical importance of this definition, let's look at a case study. In a factory that manufactures automobile parts, a contractor was hired to bring in a team of electricians to install new machinery. The electricians were not permanent employees of the factory. They were hired on a temporary basis through the contractor. Unfortunately, one of the electricians suffered an injury while working on site. Initially, the factory management tried to claim that the injured person wasn't their employee and thus wasn't entitled to compensation under the Factory Act. However, the court ruled that since the electrician was performing work related to the manufacturing process, they were indeed a worker under Section 2L, and the factory was required to provide compensation and medical support. This case underscores the importance of the broad definition of a worker, ensuring that anyone involved in the manufacturing process is legally protected, even if they are not directly on the factory's payroll. In summary, Section 2L of the Factory Act 1948 provides a broad and inclusive definition of a worker. Whether you're directly employed, hired through a contractor, or even unpaid, the law recognizes your contribution to the manufacturing process and ensures your protection. This definition helps safeguard fair labor practices and ensures that no worker is left vulnerable. Thanks for joining us